Good morning, members. It is the appointed time and we have a quorum. I call to order the meeting of the Bills Committee on Registration of Titles and Land Miscellaneous Amendment Bill 2025. We will now invite the administration to come in. Meanwhile, these are the government officials attending our meeting today. Ms. Doris Ho, Permanent Secretary for Development. Ms. Lena Chan, Deputy Secretary for Development. Ms. Chang Hoi Shan, PS for Development. Ms. Joyce Tam, Land Registrar. Mr. Eric Lee, Deputy Principal Solicitor, and Ms. Joyce Wong, Assistant Principal Solicitor from the Land Registry. Ms. Francois Lam, Consultant Counsel of the DOJ, Mr. Anderson Chan, Senior Government Counsel, and Ms. Eunice Wong, Government Counsel. While the officials are being seated, concerning the questions raised by members on the previous meeting on the 20th of June, the government has submitted a response that's CB-1-1144-2025-02. I'll ask the government to walk us through the reply. Members may press the button if you have questions. Mr. Eric Lee. Thank you. Concerning the follow-up matters from the previous meeting, or from the meeting on the 9th of June. Now, Clause 14, authenticating the application under Clause 14. Now, according to Section 14(3) of the Land Titles Ordinance, it says if any solicitor has acted in bona fide and carried out due diligence, they don't have to bear any legal responsibilities for any inaccuracies. Now, members ask what case laws we have relied on. Now, we have made reference to Cap 89 of the Conveyancing Ordinance. Now, it says that if any lawyers have acted in bona fide and if there are no other provisions to replace those conditions, then the solicitor do not have to bear any responsibility. Now, we adopt the same threshold for our bill. Due diligence means an ordinary solicitor would carry out any ordinary actions and procedures during a transaction. We are adopting the common law principles for the definition. Now, according to the judgments of Foshan Huada Industrial Co. v. Johnson, Strokes and Master, the duty of a lawyer is the professional actions to be taken within reasonable expectation of their skills and due diligence standards. We will issue a certifying guideline for solicitors after the commencement of the law. Now, the guideline will provide a reference point for lawyers in certifying the applications, but lawyers have to make their own professional judgments for each case. Mr. Ring Kong, to facilitate our discussion, can the principal solicitor tell me which order are you following? Which paper is that? Now, there are lots of letters and correspondence between the Bills Committee and the administration. Can you refer me to the document? Now, actually, we have touched upon the matters on the 9th of June on the previous occasion. How about we start with the follow-up matters arising from the 20th of June? So please use the most updated documents. So I will take that there is no follow-up matters concerning the meetings on the 9th of June. I will now move to the follow-up actions on the 20th of June. Are we on the same page? The letter that dated the 4th of July, that's the paper. So let me read out the paper's number. Paper 1144 2025-02, that's the document we are referring to. Mr. Lee. The first matter of follow-up. Under the land title regime, the latest owner has to prove the indivisible title, and one of the conditions is that the owner must be in possession of the property. Now, members ask about the explanation of is in possession of the property. That is the roles and the roles of the property owners and what does it mean by in possession. Now, Section 82(10) explains that the conditions include that the registered title owner is in substantive possession of the property, or a trust beneficiary or lessee is in substantive possession of the property. We have made reference to the relevant regulations in the UK concerning the definition of the term. Now, if the latest owner is to prove indefeasible title, they must prove that they are in substantive possession of the property, or have substantive possession of the property through an agreement or contract. Now, the possession arises from a consent of the owner. So for these occasions, indefeasible title would have been proven. Now, in terms of whether the owner is in physical possession of the property, it will be judged by the court according to the case. Now, one example is the case law of Ho Yut Po. Now, the court accepts that by owning the key to the property, it constitutes physical control and factual possession of the property. In another case law, the incorporated owners of Wavo Mansion, the court rules that factual possession is equal to physical possession of the property. So from these case laws, we can see that whether it is the registered title owner or lessee of the property, as long as there is sufficient level of physical control to the property, the court will usually deem the person to be in physical control of the property. Now, if the seller of the property continues to use the property after the completion of the transaction, that means that the seller is in possession of the property as an authorized person of the buyer. Now, according to Section 82(10) of the new provision, the buyer would be deemed to be in possession of the property as well. Now, another example is if the landlord passes the key to the property to an estate agent. The estate agent does not have sufficient control to the property, and also the owner still has a set of keys. So they would still be in physical possession of the property. So the owner would be deemed to still be in possession of the property. Now, the concept of possession of property under the Land Titles Ordinance is very important. So before the commencement of the law, we will commence publicity and education to explain the concept with some examples to the public. There are no questions. Let's move on to point B. Mr. Portier. Now, physical possession and physical control and factual, it seems that we are mixing up the concept. Now, physical possession means substantive. Now, besides physical, what will constitute actual possession of the property? Now, of course, with physical possession, the condition would have been met, but are there other conditions? Besides physical possession, what other scenarios will also constitute actual or substantive possession? Mr. Lee? Even if you are living in the property, you may not be in the property all the time. Say, for example, you may travel abroad. So according to case laws, as long as you have the key to the property, you still have the physical control to the property. Just like when you are traveling abroad, you will not lose the rights of possession. Sorry, maybe I framed my question poorly. Does it mean that besides physical possession, there are no other situations which would give rise to factual or substantive possession? So physical is equivalent to factual, but does it mean that there are no other concepts which could replace substantive possession? Now, since these two terms are interchangeable, are there any other scenarios where there is substantive possession, but it is not a physical possession? And the spirit of the law is the owner must be in physical possession of the property. We interpret the term according to the case laws I have quoted. In those cases, physical control is equivalent to factual possession. In the other case, physical control equals physical possession. So, looking at the two cases together, as long as you have the key, it means you are in possession of the property. Now, to determine possession, I think it is best to leave it to the court. But it seems we are making up two different concepts. There must be some scenarios where physical doesn't mean factual possession. Now, you are repeating yourself, Mr. Lee. I know what the case law says. But there must be a reason why there are two different terms. So it seems the concept is too rigidly defined. Are there any scenarios where factual possession doesn't mean physical possession? Now, the case laws equate the two together. So I don't think Mr. Lee has an answer now. So Director or Land Registrar. Now, Section 10 of the law says physical possession. So our concern is how this term is established. So we have identified some cases to illustrate what constitutes physical possession, and we are not trying to define what factual possession is. I think the member understood where you were coming from. He was asking, besides these two case laws, are there any other scenarios where physical possession can still be established? We will conduct some research afterwards. Yes, because you are saying physical means factual. So is there a difference? If there is not, let's just define physical possession as factual possession, and that's it. But since there is this term factual, I think physical is one of the conditions defining factual, but not the only component.
Mr. Kong, I don't have comment on what they just said. I want to confirm with Mr. Lee, however, that according to the Law Society submission, the Society raised an issue, and that is, as I mentioned at the last meeting, about deferred possession. In the event of deferred possession, the buyer, on the date of transaction, is unable to hand over the property for possession by the other party because there is no physical possession. So according to Law Society, there is no physical control being passed from the vendor to the purchaser. So it is a very important concept, and public education is important. So do you agree with Law Society that the scenario of deferred possession will happen, and that public education is key? The government does not, in such circumstances, encourage deferred possession, and that there is a caveat emptor for purchases. Now, we emphasize that we do not agree with the Law Society's suggestion. We are of the view that whether or not he lives in the property or he is occupying the property, he does so with the consent of the seller. So it's called license. What constitutes a license is for the landlord to allow a person to occupy the property. Otherwise, without a license, this person will be trespassing on the property. So, of course, consent must have been sought before the property is occupied. In such circumstances, the person occupying the property is a licensee. So that means there is no concept of a deferred possession, right? Because either you have permission, that means license, or you don't, which means trespassing. Deputy Chair. Right, I fully appreciate that you may not fully see eye to eye with the Law Society. It's very common that divergent views are expressed in the legal profession. So please make sure that the response is addressed. Mr. Paul Chair. Right, my concern is not just about the government disagreeing with the Law Society, like Mr. Kong have said. Well, it's a case of diversity. There are divergent views, and also, Mr. Lee, you just gave an example. Let's say if the property is given on trust to somebody, or license is given to somebody as an agent who acts as a trustee with the keys handed over, then it's factual. It may not be a factual possession, because under common law concept, the landlord or the new buyer has acquired title, but physically the seller allows the property agent, or the buyer allows the property agent to be in possession of the key, or the old landlord to be in possession of the property for the time being. So perhaps it's a Freudian slip, Mr. Lee. You just now mentioned the other terminology, and it's really a confusion, especially in the Chinese terminology, because when you say physical possession, it means something tangible that you own in physics, where in the physical world, whereas in factual possession it means something else. I think in Chinese, the different terminology, 實質 and 實際 cause confusion, whereas in English, there is a clear distinction between physical and factual. So please go back and consider the terminology. Mr. Ambrose Lam. Well, as far as the legislative enactment is concerned, I think it's all right if the government uses physical possession as long as there is a clear explanation. Well, you may even use another term, actual possession, but this will cause even greater confusion. So for physical possession, there may be new circumstances arising in future. And it may be very difficult to give a clear definition given the broad scope. The courts, however, will have regard to the actual circumstances and provide a fair and equitable explanation of the term. I don't think we need to be too worried about the court's interpretation of the term at this point. Mr. Paul Chair, well, I respect the views of the representative of the legal sector, but I'm still of the view that we need a new definition. In the government bill, you can provide, for example, A equals B, but if all of a sudden it goes to the contrary, I'm concerned that there will be a great confusion because of the previous case laws. We are revamping the land registration system, so I hope the administration will not only listen to me or Mr. Lam. Rather, for Law Society submission, it comes from the whole legal professions. So you should make sure the point is addressed. Make sure there is no confusion on the use of terminology in the new system, so as not to cause confusion. It's a very cumbersome process for the court to interpret the statutes because of the common law system that we have been practicing. Ms. Maggie Chan. Thank you, Chair. I'd like to offer my take as well. Now, about possession, we talked about license and licensees. In the past, there was a dispute over license and tenancy. So as far as the law is concerned, it means actual possession. So if we have, say, a short-term tenancy, how should we define what it means? I want to put that on record so that the legislative intent can be reflected in a better way in future. Now, for actual possession, I'd like to ask the administration to elaborate on this, whether it means exclusive possession. You may give out keys to different agents so that many can have access to the property. That's the case of the landlord selling the property. The landlord may have entrusted different agents to sell the property. Is it exclusive possession? This is just one of the examples. I'm interested in the principle of this concept, that it's exclusive possession, and to what extent is actual possession different from exclusive possession. Like other members said, this is a novel concept, and yet we are not scrapping the old system altogether. Very soon, the two systems will go in parallel. So don't tell me it's all about public education. You have the new land first approach, and you are going to introduce a new system running in parallel with the old one. I think on record we need to make things very clearly in black and white. Right, to address members' point on whether it's a license or a tenancy. Every now and then, we hear about legal disputes. But as far as the law is concerned, both tenancy and license are captured. So either tenancy or neither tenancy nor license would affect the status of physical possession. Whereas for the second point about exclusive possession, it's not part of the bill. It has to do with, for example, whether it constitutes a tenancy. Whereas here, we're talking about the elements of physical possession. And according to case laws, it refers to physical control. That is, the focus is on whether the party is in control of the property. Now, one example is an agent in possession of the key, and occasionally this agent will bring prospective buyers to view the flat. So it's a matter of the extent of control, whether it lies with the agent or with the landlord. And for the latter example, a licensee, for example, as long as there is a sufficient level of control, it should meet the requirement in subsection 5. Ms. Maggie Chan. That means under the new land first approach, and I take this common scenario. If I am the landlord and I give exclusive right for an agent to sell my property because I don't have time, I'd like a manager to help me with that. So I allow the agent to help me sell the flat exclusively, and that after the property has been sold, this agent will also help me manage the property by receiving rent. So will this agent be regarded as having actual possession? This agent helps the landlord sell the flat by, say, taking people to view the flat and receiving rent. And I assume that this tenant will be the tenant of the landlord and not the tenant of the agent. So it fits the criteria, or one of the criteria of physical possession. That, Ms. Chan, I'm sorry, but it seems this explanation goes against the first one that you gave. Now, the first example refers to an agent being in possession of the key to allow people to view the flat, and in that sense, this agent is a licensee. What about exclusive right? If he's an exclusive agent who is in charge of selling and managing the property, then this agent has sufficient physical control as to constitute the physical possession of the property. Now, using the same example, after the property has been sold, if the property is then leased to a tenant, the property is still owned by the landlord. So the tenant is the tenant of the landlord. And the tenant is allowed to occupy the property on the payment of rent. And the landlord is therefore controlling physically the property.
Let's spend some time to digest the answer. Next, Mr. Louis Leung. Chairman, I read through the letter from the administration dated the 4th of July. I thought I understood what it means by physical possession and factual possession. However, having heard the questions raised by my learned friends today, I learned a new term, that's actual possession. I don't know what the Chinese translation for that term is. I may be a bit slow in figuring out what it means. But since the meanings of the three terms are so important for laymen in the market, I believe the government must define the three terms very clearly. That may not be possible in today's meeting. So I will urge the government to supplement other papers and information to clearly define the three terms for the public's benefit. Mr. Lee, in the bill, is it the case that only one of the three terms is referred to? You made reference to the other two terms, just for the sake of explanation. I agree, however, that it is important to explain the meanings of the terms, no matter how well defined the terms are on paper. So, may I ask what the government's position is on this point? Let me clarify. The term physical possession is used in the context of this piece of law. So we are quoting some case laws to explain why it is equivalent to factual possession. In the bill, however, we are just using the term physical possession. In the future, we will use case authorities to explain what this term means and when would the condition to be deemed as fulfilled. P.S. Now, this term, physical possession, is very important. So having heard the previous discussion, I think we need to make more efforts in education. And I think we need to supplement a paper to the Bills Committee to explain how we should construe this term, physical possession. Mr. Paul Jie's question was valid. Now, according to the case laws, is physical possession the only way to fulfill actual possession? So we will try to identify other case laws to help clear up the matter. Thank you, Permanent Secretary. Deputy Chairperson, Mr. Rin Kong. Thank you, Chairman. I think the matter of actual possession should be explained in detail by the administration in subsequent papers. In Hong Kong, in many cases, the concept of actual possession has come up, so we have to deal with the matter carefully. Another question, license use of the property and franchise and so on. Page 143, Section 10C of the law. Now it refers to Section 10C of the law. Now when it comes to licensee, are you referred to a written license or unwritten one? Mr. Lee, we make no distinction between them. As long as a consent or approval is given by the landlord, that would constitute a license. It can be in the form of conduct or in written form. So I think the Permanent Secretary has made the point clear on this point A. Factual, actual, physical, there will be supplement documents to explain the matter. Mr. Porget, thank you, Chairman, for your summary. Now I have two observations, though, arising from Ms. Maggie Chan's question. Now in the industry, we don't have to define the relationship so clearly between the estate agent and the landowner. They can be viewed as a single entity. They are acting on behalf of the landlord. You can say that they are the licensee, but more importantly, they are the agents of the landlord. Now, I had some time to study the case law again. The case in the UK. The court made a distinction between physical possession and actual possession. So the two concepts are not mutually exclusive. There are some common components. So maybe it would be best if we have a separate definition for the term in the bill. To educate the public, we must educate ourselves first. Otherwise, it would give rise to confusion. If even the industry doesn't understand what it means, the public would have no hope to understand it. Thank you, Mr. Porger, for your elaboration. So the administration should explain the matters more clearly in the future. Now let's move on to point B of the follow-up matters. Now Section 82, Section 82.5 and Section 88.1 makes reference to a person who has substantially contributed to the fraud, the mistake or omission, making the instrument void or voidable, or who has substantially contributed to the loss. Now members ask for a clarification of the meaning or scope of substantially contributed to in the above two provisions. Now, according to Section 82.5, if a person had, by the person's act or by lack of proper care, substantially contributed to the fraud or caused the mistake or omission, then the person will not be deemed to be in bona fide possession. Now, the purpose of the provision is to exclude owners who are not acting in bona fide to possess indefeasible title. Now, lacking due diligence usually refers to due diligence taken by a reasonable person under ordinary circumstances. Now, substantially contributed to depends on the facts of the case. The court would make a ruling on each case. Now, for a case involving fraud, now if the seller claims to be a licensee of the landlord to sell the property on the landlord's behalf, however, the authorization letter or power of attorney does not specify the validity period of the authorization. Then the legal representative acting on behalf of the buyer is doubtful of the validity of the power of attorney and requires a new power of attorney. Now, however, the buyer ignores the doubts of the legal representative and completes the transaction because of the lower price of the property. And subsequently, it was found that it was a fraud. Now, for such cases, the court may find that the buyer has acted below the threshold of due diligence and they will not enjoy indefeasible title. Now, for mistakes or omission, say for example, if a parking space number 22 is sold, however, in terms of conveyancing, the parking space was erroneously described as number 23. Now, if the former owner applies for a rectification, the court may rule that the buyer, in preparing for the conveyancing application, did not act in due diligence and has contributed to the mistake substantially. then the court may rule that the buyer does not have indefeasible title of parking space number 23. Now, for invalid instruments, before conveyancing of a HOS property, if the buyer did not conduct due diligence to check whether the premium has been paid, so that the restriction of conveyancing has been lifted, then the court may consider that the buyer has not acted in due diligence and has substantially contributed to the invalid transaction. Then the court may rule that the buyer does not enjoy indefeasible title. Now, other examples include behaviors falling short of due diligence on the agent's part. Now, for example, if the agents have neglected the power of attorney or premium paid for lifting conveyancing restrictions, these would be deemed as the negligence on the part of the buyer, and the buyer would be deemed as having acted below the standard of due diligence.
代理人嘅行為咧，即係 agent 嘅行為咧。
Now, according to the UK authority, the behavior or actions done by the agent would be deemed as acts done by the buyer. Now, there is only one paragraph left. Let's finish this paragraph and then I will open the floor. Thank you. Section 88, brackets 1. Now, if someone was a party to the fraud and has substantially contributed to the laws connected with the fraud, then the government can cover the indemnity paid from the person. Now, if a legal representative acted on behalf of a fraudster to sell the property, then both parties have substantially contributed to the loss. Now, if the buyer is granted indefeasible title, then the land registry can make an indemnity to the original owner and then recover the indemnity from the lawyer and the fraudster. Now, the level of involvement in the fraud will be judged by the court based on the facts of the case. Now, the amended Section 82.5 and 88.1 seek to explain the policy intent and are reflected in the Land Titles Ordinance. Thank you, Deputy Chair, Mr. Rin Kong. Thank you, Chair. I have two questions. Now, thank you, Mr. Lee, for giving us some examples. Now, in the first example, I will approach it like a reader of a detective novel. Now, there are several presumptions. First of all, the power of attorney has been entered into for quite a number of years, and the lawyer acting on behalf of the buyer is doubtful of its validity. Now, according to this example, despite the fact that the power of attorney has been entered into for many years, the signature is legit. So what's the problem here? And the second example, according to Section 82.5, you only mentioned that the person has contributed substantially to the fraud. So you are only saying the person. So if you are actually targeting the agents in mind, shouldn't you specify agents in this provision. I know agents are also covered by the definition of person, but I think you have to make it clear.
Mr. Lee. The first point you raised is about the power of attorney being signed years ago and that the signatures look similar. The lawyer may not find the signature suspicious, and that means it may not be a case of a lack of reasonable care. Now that depends on the court's view of the facts, and that there may not be circumstances arisen which caused the lawyer to become suspicious, and that is not a case of a lack of reasonable care or due diligence. Now, whereas my example is that apparently something has gone wrong, and yet because of lack of reasonable care, the conveyancing process continued. Right, what about the next question about the agent? Well, I think the agent's acts will be deemed as the acts of the principal. That's a really general legal position. I don't think we need to spell it out in the provisions of this bill, because in other provisions, similar circumstances may arise. We refer to the acts of the person, including the acts of the person's agent. Right, I don't need an amendment to be made as long as you confirm that this is the case, because in section 82.5 there are references to the persons and the Persons Act. So as long as the government has explained that the acts of that person includes the acts of the person's agent. Ms. Maggie Chan. I want to go back to the first example and the duty of care of the lawyer. Now, in this example, it is assumed that the power of attorney is fake, and that, as we all know, the POA is good for only a year, and at the lapse of a year, the person authorizing the sale of property will need to make a declaration for the POA to be in force. Now, your example is that years have passed. There may be suspicions about this POA, but as long as the person giving the authorization confirms the validity of the POA, then under the common law system, the lawyer will have fulfilled the duty. Or is it not the case? My second point is this. Now, using the same example, the consideration value is low and there may be some doubts. The lawyer has asked the buyer not to go ahead, but the buyer insists. So does it mean that the lawyer will be responsible for the problem? The third point is this, about the lawyer's duty of care under the new land first approach. I'd like to know whether there are views already formed on the lawyer's professional indemnity insurance. Mr. Lee, the first question is about the validity of the POA. After 1 year of signing the POA, is it necessary for the landlord or the person giving the authorization to provide another statutory declaration, and that whether it constitutes professional negligence on the part of the lawyer if this is not done or if it involves fraud? As mentioned at the meeting of the 9th of June, the lawyer's duty of care refers to a professional lawyer exercising due diligence and reasonable care as expected by their peer. That means, in that sense, I don't think there is professional negligence on the part of the lawyer. Perhaps it may have to do with the trickery of the fraudster and that even the lawyer has been tricked. Right, I want to clarify. I just want to put it on record. I think his explanation is clear. So for the example that you cited in the paper, that lawyer is in professional negligence. But you mentioned another example. The lawyer has requested the fraudster to provide a statutory declaration, and the lawyer is tricked by this fraudster as well, and that means the lawyer has fulfilled his duty. I think that depends on the court's ruling. We have explained the criteria at the meeting of the 9th of June. I am not in a position to answer whether the lawyer is responsible in each and every case. I think the matter lies with the court. But in principle, if the fraudster is so skillful that nobody detects fraud, then I don't think the court will rule anyone in breach of their professional duty. Now, about the second question, whether the lawyer should continue to act for his client, I think that depends on the professional code of conduct formulated under the rules. Ms. Maggie Chan. Right, I understand your point. You mentioned discussing with the Law Society about the professional code of conduct. I am a lawyer by profession. So if you ask me, the offer is so tempting. The value for consideration is so low. It warrants a suspicion. But despite my warning, the buyer would like to go ahead. You need to work out an arrangement with the Law Society. Right, I think the crux of the matter is whether the lawyer is responsible. As I understand, if the lawyer does not have the duty to act in a certain way in these circumstances, then that's up to the individual judgment of lawyers. Yes, I understand Ms. Maggie Chan's request and that we should talk to the Law Society and draw up the relevant rules and guidelines. In fact, in the draft, we'll be talking to the Law Society about power of attorney. What exactly should a lawyer do? For example, a lawyer should check documents very carefully to see whether the authorization is valid. There should also be communication with the person signing the POA. The lawyer should initiate contact with the person giving the authorization. A set of rules will apply. After completing the scrutiny of the bill, we will review the draft and see whether the relevant provisions should be enhanced. Mr. Lee, what about the third point, professional indemnity insurance? I'll try to take this question. Now, after the enactment, after we've drawn up the bill, we've talked to the Law Society about professional indemnity insurance, and they will assess the impact on their profession, including the Section 88(2) capital A about professional indemnity insurance, and that an additional provision should be included. That is, the claimant's claim should be conclusive, and that there should not be any further claim against the Law Society. Now, I believe they have assessed the implications, but they've not told us what they will do about that. Right. They still have a year or so for preparation. They will be talking to the Law Society and the relevant stakeholders. Ms. Maggie Chan, thank you. Now, my point is, after the bill has been passed, the administration should talk to the Law Society. They should also engage the insurance sector because it has to do not only with lawyers but with the general public. They deserve protection as well. Right, there will still be time for preparation after the enactment. So for the codes of conduct and guidelines, I'm sure that you will talk to the relevant parties. C. Members note that Division 12 of Part 2 proposes an amendment and that omission does not include a failure to lodge an application for registration, whereas in Division 11, it does not clearly state whether this is the case. Now, we have considered the position and we will be amending Division 11 to add the relevant provision. Right, I don't think there is any question on this. Point D. Members point out that from time to time, there are cases in which a person has purchased a residential property under construction, that means uncompleted flats, and the purchaser would sell the property before completion of the transfer procedures. The question is whether any loss arising from fraud in such a transaction will be considered as a loss of indemnifiable interest under 84A. Our position is this. Signing the sale and purchase agreement would make this party a beneficial owner but not the actual title owner. So this loss in the event of fraud will not be considered as an indemnifiable interest. Under the current title registration system, the Nemo-Dat rule under common law applies. That is, the fraudster is unable to deliver what is not his to the next party. I mean, that's for the current registration system. Under the title registration system, the court is entitled to hand down a rectification order, even in the event of a fraudulent transaction. However, the developer's position will not be affected as the beneficial owner. That means it's not an indemnifiable interest. Right, if there are no questions, next. Point E relates to professional remuneration. 86C refers to reimbursement of professional remuneration in relation to indemnity applications. Members would like a clear explanation about this term, professional remuneration. 86C refers to professional remuneration arising from the indemnity application. So it relates to indemnity applications. It is not applicable to the example member earlier cited, that is about the private detective, which is not relevant to indemnity application. Now, we've given some examples. For example, engaging a surveyor to gauge the loss or the interest incurred, and also engaging a lawyer to prepare for the necessary documentations. Now, in Cap 124, the Land Resumption Ordinance, similar provisions can be found. For example, Section 8.4, any person who submits an application under subsection 1 including a claim involving the engagement of any person in his professional capacity to handle the applications and the relevant fees, expenses, or remuneration reasonably incurred, including the claim against the government, will be indemnified. We'll make reference to the Land Resumption Ordinance. And reasonable expenses and fees incurred in relation to the claim, including the professionals to be engaged, the professional qualifications applicable. These will be set out in the subsidiary legislation.
Any questions? There being none, let's move on to the next point. Item F. Some members have noted that in the case of a property fraud, the administration has a right to, including being subrogated to, recover the amounts of indemnity paid from the persons who have caused the loss. Members inquired about how the administration would ascertain the proportion of contributions of persons involved in causing the loss for determination of the amount to be recovered. Now, Section 88, brackets 1 says that in case of a fraud involving property, the government shall be entitled to recover the amounts paid from any persons who have caused or substantially contributed to the loss by their fraud in proportion to their respective contribution to the loss. Now, during the discussion in 2020, this clause has been added according to stakeholders' views. Now, in cases where two or more persons have to share the blame or responsibility, the government should recover the amounts paid from these persons according to their respective contribution to the loss, rather than recovering the entirety of the loss from one of the persons. Now, we have adopted that proposal in the final version. Please move on to the next point. Item G, regarding appeals against decisions made by the registrar. Now, there were suggestions to replace the reference to solicitor or counsel with legal representative. Now, we have noticed that in other ordinances, if the term legal representative is used, then the definition for the term would be added to the interpretation part. Now, since we have specified solicitors or counsel in Section 91(3), it has already reflected our policy intent. We don't have to replace them with the term legal representative. So we should keep the existing descriptions. Now, finally, point H. Members requested us to summarize in tabular form the contents of the offences specified in Section 98 of the Land Titles Ordinance, and also include specific examples, penalties, and comparisons with similar offences under other laws. So we have done exactly as asked. We have listed out the offences in tabular form according to their severity, and also we have quoted examples and made a comparison with other penalties in other ordinances. And thank you. I would like to go back to point E, a professional remuneration. Now, is it the case that whether the transaction is successful or not, the lawyer can still get the professional remuneration? Now, as you may know, starting from 2008, I have been making statutory representation for the residents in the new development area. As long as the residents are not happy with the ex gratia payments, I can file the application. Now, even if the application is rejected, if the lands department does not think the price we quoted is reasonable, the lawyers have still done their work. Now, in the context of indemnity application, the implication is much wider. It applies to the entire territory. So how would you define professional remuneration in the context? We would only reimburse the professional remuneration if the case is a success. Now, for the case of land resumption, there must be compensation. It's just a matter of how much. However, for this context, compensation or indemnity is not a must. Now, under the Land Resumption Ordinance, there are also some issues arising from the change, but I will not mention them here. Bottom line is, the reimbursement of professional remuneration or indemnity is premised upon the successful conclusion of the case. Ms. Maggie Chan. Chairman, I still have one more questions about the overall matters. Now, a case law in the UK was mentioned. Now, our new land title system, is it very similar to the one in the UK, or are there major differences? I want to put on record the legislative intent of the government. Now, we are legislating for the new land approach. This is something new, so we can only rely on case laws from other jurisdictions, one of which being the UK's. But we have to see whether the cases are comparable to our situations and principles. If the concepts are very different and incomparable, then it would not be suitable to rely on the case laws in the UK. Mr. Lee. Now, our provisions are quite similar to that of the UK, but there are some differences. In the UK, they use caution, but we use caveats. Now, I believe the court will make reference to the case laws. I will not say those case laws are applicable, but they have reference value. Now, in the UK, they use caveats, but we use caution. If that's the case, the reference value would be minimized. But we are both common law jurisdictions. The principles in those jurisdictions are still valuable. Ms. Maggie Chan, may I trouble the solicitor, the principal solicitor, to tell us what's the major difference between the regimes in Hong Kong and the UK? If not, please supplement the information after the meeting. Now, if we have the major difference between the two regimes in mind, then in the future we will know that in certain cases the UK legal authorities will not apply. What came to my mind instantly is the difference between caveat and caution, but we will submit some additional papers after the meeting on that. Mr. Tony Jie. Now, I don't have any questions about the follow-up matters from the previous meeting. My concern is only in relation to professional remuneration. I agree that we must sort it out clearly. Now, the lawyers or the parties must understand the legal fees involved. Now, the applicants are usually laymen, and they would engage professionals to help them. So if the case does not succeed, then the legal fees will not be indemnified. Now you said in the bill that the applicants must prove that there is an actual need for engaging legal representative. But that's not very clear. So as you have said, after the commencement of the regime, there are still a lot of follow-up matters to be considered. So will the government make regular reports to the council in terms of the amount of indemnity paid and also the progress of cases pending? I think the permanent secretary or the secretary has promised to come back to report to the council concerning the land boundaries and also adverse possession. Permanent secretary, if I remember correctly, the secretary for development was referring to the conversion of existing land, because that question was raised by several bills committee members. Was there a timetable and what's the government's position? So the Secretary for Development said we will come back to report to the panel or council next year. But since this bill has a huge implication on the public, at a certain stage, if we have achieved some milestones, for example, after the passage of the bill this year, next year we will introduce subsidiary legislation into LegCo. After that, we will schedule a report to the panel on development to brief members on our thought and position on the timetable for conversion of existing lands and also our arrangements for public education. Thank you. Now, once again, professional remuneration is a matter that we need to clearly define. We must make it known to the public. The operation is very different from the Land Resumption Ordinance. Mr. Paul Chair. Now, the last point on caveat and caution. Now, can Mr. Lee remind me whether we have a definition for the term caution in this bill? Sorry, it has escaped my mind. Number caution and consent caution. Now, after a transaction contract has been entered into, then consent caution can be signed. For non-consent caution, anyone who has a claim to the property, for example, if I want to litigate against a person for the claim to a property or a piece of land or make an application for ratification, then that would be a non-consent caution to make it known that legal procedures are ongoing for the land. If the claim succeeds, then the rights would be subject to the claim. Thank you, Mr. Lee. I just want to understand whether the UK's practice of caveats is defined like our caution practice. Sorry, I don't have any details right now. In terms of the actual operability of caveats, I don't have any information right now. So please explain that to us in the supplementary paper. Yes, it can be called caveats, caution, warnings, and so on. The point is there is an encumbrance on the deed. I'm worried that there is an established definition for caveat in the UK, and that is very similar to our practice of caution. We don't want to send a message that caution is completely different from caveat. On the contrary, we should send a message that we can refer to the caveat system in the UK because the nature is similar to caution. It's just a warning to the public that there is something going on with this piece of land and you have to be cautious. So I hope that this would be explained more clearly in the supplementary document.
The next question is about engaging any person in their professional capacity. Now, one example is this. Let's say in the case of a fraud, if I engage a handwriting expert to determine the authenticity of the signature, then this person deserves professional remuneration. Let me clarify. We're referring to professional remuneration for the purpose of indemnity applications. You mentioned fraud and fraud detection. That's the stage before filing any indemnity application. Right, so in the first half of the game, we consider whether there is fraud. In the second half, we're talking about the quantum or the quantity of loss, and that we specifically refer to surveyors and professional lawyers. Now, the third point is about proportion of contributions of persons involved in causing the loss. This is to be determined by the court. In paragraph 20, am I right to suggest that in the first half of the game, if the court grants a rectification order, then there is a determination. There is no need to consider that in the second half of the game. Whereas if there is no recommendation or rectification order passed in the first half, then in the second half of the game, you will determine the proportion. Is that right? Well, it is, but in the first half of the game, the focus is on rectification order. That's basically to determine whether a fraud has taken place. Now, in the first half of the game, the dispute is between the original landlord and the current landlord. So the court will determine whether a rectification order is necessary because of a possible fraud. Right, this may not be applicable in the case of fraud, but in a professional negligence on the part of a lawyer versus the client's negligence, then even in the first half of the game, this will be touched upon. Or is it that, as you mentioned, in the first half of the game, it is totally irrelevant? Section 88 refers to the proportion of contributions, and Section 88 subsection 1 refers specifically to fraud. So for the proportion of contributions of the persons involved, 88.1 should not apply. Now, would Mr. Lee further elaborate on the following? In the first half of the game, will there be any determination on the proportion of contribution expressed in percentage terms? Well, I still don't think there is a great chance this proportion will be determined in the first half of the game, because the first half is about rectification. It's not about determination of contribution and their respective proportions. In the first half of the game, it involves the original owner and the current owner and not anyone else. I'm sorry, I thought that we are referring to different scenarios apart from fraud. Now, for other scenarios, they relate to indemnity applications. If we are to recover the amount, then we should look at Section 88, and that 88.1 refers only to fraud. That means in other circumstances there is no indemnity or recovery of indemnity paid. No, not true. In 88.2 there is recovery of indemnity paid, only that there is no proportion of contributions of persons involved in causing the loss. Now, we added this expression on the request of stakeholders back then. For example, if two persons are held liable the court will usually rule on the basis of joint and several liability. I think this concept is generally understood, and back then some stakeholders were of the view that it would not be desirable for a lawyer to file a claim against a fraudster because lawyers generally are in a better financial position. So the concept of joint and several liability should be dropped. Right, please don't use expressions such as the first and second half of the game. Just explain to us what the arrangement entails. For clarity's sake, Chairman, sorry, I started the expression. The confusion is all the fault of my own. So let's talk about rectification stage and the determination of indemnity, of proportion. Well, only those who are football fans will understand first and second half. Anyway, Mr. Lee, according to your analysis, in Section 88(1) was put in place on the request of stakeholders, as you explained, but adopting the same logic, ascertaining the proportion of contributions in the event of fraud may not be as common as the need to determine the proportion in the general case of negligence. Well, in theory, if we are to keep the same expression in 88(1), it should be reasonable that the same expression be included in 88(2) as well. Because when it comes to fraud, it's a zero-sum game, whereas in the case of a negligence, it could be a 50-50 contribution. At least there is a higher chance that different parties will be partially contributing to the negligence. So please consider including the same expression in 88(2). Right, Mr. Lee? Well, if you ask me, I'd say drop the expression for both provisions. Well, you talked about the historical background and that the expression was included on stakeholders' request. But as far as the logic is concerned, it's more appropriate to include the expression in 88(2), given the negligence background. So to maintain consistency, you should either drop both of them or include them in both provisions. Right, perhaps go back and consider Mr. Paul Chair's suggestion. I'll give you some time to think about it, give us a written response, all right? So if there are no further views, I think we can now turn to the administration's response to Law Society submissions. That is CB bracket 1 1054 stroke 2005 bracket 02. The Law Society made a submission in English on the 20th of May. The Development Bureau gave a response in English on the 19th of June, and then on the 27th of June, the Chinese translation was provided. The Law Society made a further submission on the 2nd of July. We haven't had time to provide a detailed response, but when I go through the relevant points, I'll first explain the further views of Law Society before giving us our preliminary views. Well, we appreciate that the Law Society's paper was only received on the 3rd of July. I think members would agree that the administration could provide a written response later. Now, first focus on this paper, CB bracket 11054/2025 bracket 03. Paragraph 4 of the submission refers to long-term lease. According to the Law Society, long-term lease refers to the whole lot of land. But in 26(2), long-term lease also includes lease of undivided share in the land. The Law Society sought clarification of the legislative intent. As we conducted clause-by-clause scrutiny of the bill, we explained that for long-term lease, it applies to the whole lot of land, but when it comes to the relevant provisions after the lease has been generated, the undivided shares will also be included. That means 26 subsection 3. One provision refers to generation, the other refers to applicability. There is no conflict. Paragraph 4.5 of the submission, the Law Society refers to the grant of a long-term lease being paid by installment, and that in such a case, the arrangement would no longer be a long-term lease, and we agree that the grant should be paid in one go for aligning with the policy. Next, paragraph 5.4 about short-term tenancy. Short-term tenancy is not part of new land. So paragraph 5 of the Law Society submission suggests that we should categorically specify that short-term tenancies are only to be granted by the government to avoid privately granted short-term tenancies from being excluded from the definition of new land. Now, our response is this. Short-term tenancies definition only exists the term short-term tenancy only exists in the definition of new land, and there is no confusion and no need for further amendment. There is no further view from the Law Society. Paragraph 6 of the submission. Under Section 4.4 of the LTO, the Law Society is of the view that the title register provides irrefutable evidence. And according to Section 4.3, deeds pending registration does not form part of the title register. So the question is, after the application comes through, will this appear on the title register? Now, according to our response, the title register will contain an entry called pending applications. Under the deeds registration system, the similar entry, deeds pending registration, will appear, and the entries are similar in nature. There is no further view from the Law Society. Paragraph 7. The Law Society refers to Part 5 of the LTO, or the objective as well as the operational details. We are of the view that it operates in the same way as the Memorial Day book under the current land registration regulations. Now, no further views have been received from the Law Society. Next, paragraph 8. According to Section 15A, the date to be considered is the date of registration, and that in the event of relodging an application for the purpose of clarification or supplementary information, whether the date of application be affected. Our response is that the date of application will remain the same, and that there is no further view from the Law Society. Next, about date of first registration of the new land, paragraph 9.2, and whether the date of submission of application will be affected. The answer is in the negative.
Paragraph 10. Public inspection of registers and documents under the Land Titles Ordinance. Now, according to the Law Society, Section 30 of the LTO seems to have been tightened. So they ask what information and documents must the applicants for an inspection provide. Now, the practice would be similar to the existing practice under the Land Registration Ordinance. Now, only specified persons can inspect the past information concerning land registration. Now, since our meeting has gone on for quite some time, maybe the government officials need to take a break. So let's have a break of 5 minutes. Thank you.